Good afternoon, everyone. I'm Judge Eugene Fahey. Judges DiFiore and Rivera are recused in this action. Counselor, do you want to reserve some time?
Yes, Your Honor. On our
3 minutes?
main argument, 7 minutes, 3 minutes for rebuttal.
Whenever you're ready.
Thank you, Your Honor. Good afternoon. May it please the court and counsel. My name is Deborah Scalise, along with my colleague Annette Hassapidis. We're here on behalf of Larry Hallock and Mary Malerba. This case is about issues of fundamental fairness and due process. Every party in every case in every court of the United States is entitled in our system of jurisprudence to know what the allegations are against them.
Counsel,
Yes.
here, sorry, it's a little hard to mask, but I understand your argument. Let's assume, and I know you dispute this, but let's just assume for my hypothetical that there was, that a finding of dishonesty was supported in the record. But same charges, same violations that were admitted to, but the finding of dishonesty is clearly supported by the record. In your view, would that be a due process violation?
Yes.
Why?
The reason being that there was never a dishonesty finding.
No, but let's assume.
Oh, you're assuming, okay.
Yeah.
So, okay. Judge Castell, in this record,
No, but let's assume there was a dishonesty finding. Would it be a due process violation?
well, the problem we have here, and let me just add, if you don't mind, to your hypothetical. We started in one court, we then went to the Southern District grievances, okay? And they rely, our court, the appellate division, relied on what happened in the Southern
No,
District
I
grievances.
understand. I guess I'm not articulating this well, but I think what I'm trying to get at is, assume there was a basis for finding dishonest conduct here, and I know you dispute that, but just assume in my hypothetical there was. It seems to me your argument would be the same because you would be arguing, but you weren't charged with dishonest conduct. That seems to be the basis of your argument.
Yes, you do need notice and the opportunity to be
But why
heard.
wouldn't that just fall within 8.4, conduct unbecoming, for want of a better phrase
Okay,
here?
so conduct that adversely reflects on the fitness to
Doesn't
practice.
dishonesty adversely reflect on you?
Well, under 8.4, if you were to take a look at Smollear's decision, he was actually charged with 3 violations in addition to 8.4H, A, B, and
Yeah.
C. A and B are dishonesty charges, and they have to have intent, okay? C is an administration of justice charge. The only way our court could get to dishonesty on the part of these lawyers was if they had been charged with that. They were not in the
No,
instrument.
but let's just say there was a finding in there. For some reason, they admitted 4, but there's a sufficient basis to find dishonesty. What I'm getting at is, it seems to me the problem here isn't so much you were, found to have violated a rule that wasn't charged. It seems to me the problem is, in this view of your view of it, there's a finding underlying a penalty that isn't supported by the record.
That's part of it, but the real issue is you had 2 separate proceedings with 2 separate respondents. You had Mr. Smollear, who had a confidential collateral proceeding where he had the opportunity to present mitigation and testified. You later have this proceeding on a reciprocal discipline with our clients who apply pursuant to the reciprocal discipline rule based on the Southern District of New York's findings. The Southern District of New York's findings, and I'm sure, Judge, that you're familiar with this because you used to appear there, the grievance committee there is made up of judges, okay, who sit and review the record, just like the appellate division does for our grievance committee. The difference being is the judges actually decide whether to go along with it. So there was a censure for each of our clients, and that censure, if you take a look at it, does not allege any 8.4 violation except for H, which is the adversely
And
reflects.
I understand that. It's just how I'm trying to fit your allegation of what's wrong here, your argument about what's wrong here, within a framework I can kind of understand. Because to me, it seems more as if what you're saying is accurate, if there's no basis for finding of dishonesty, the way the appellate division to me seemed to use that finding was to enhance the penalty. It wasn't to find that you violated another, the case from the Supreme Court where they add a violation later, or, it was used as a penalty enhancer.
Well,
And to me, if there's an aggravator in the record, and they would have said, oh, look at what happened in the Southern District, admitted conduct, even though that doesn't fit neatly within the first 3 violations, but it doesn't reflect very well on a lawyer appearing in federal court or any court, why couldn't they use that without a due process violation? You've admitted the conduct. The problem here is you're arguing they're using something you have not admitted that isn't in the record, but they were using it to enhance a penalty.
Yes, but even in enhancing a penalty, a respondent should have notice, any attorney should have notice, or even a judge for that matter, of what they're being charged with. Here, the appellate division relies on Smoliar, who, if you read Judge Castell's opinion, and he was the original fact finder, is repeatedly called a liar, a lone wolf. He's the one who submitted the original affidavit. And there's a footnote by Judge Castell which says there are some differences that are so great, I'll leave it for the grievance authorities.
Did they ever do that, though?
They did not do an investigation. They did not do an investigation. What happened was, pursuant to the rule, and if you
That's
take
okay.
a look at the rule, it just says that the respondent may file an affidavit stating defenses to the imposition of discipline and raising any mitigating factors. They filed their affidavit. They followed the procedure. They did not have a hearing. The appellate division and the grievance committee could have expanded upon that by saying, we want an investigation because there are so many inconsistencies in the record, and we want to know who's being honest.
And they never did that.
They
right?
never did that. The grievance committee did not amend its pleadings. They had a very terse pleading based on the grievance committee for the Southern District, and there's nothing in either of those that mention any dishonesty allegation. The only way you get to the dishonesty allegation is by coupling Smoliar, which is mentioned, okay, with this. Now, if you hold up Smoliar's case and the charges that he was charged with in the Southern District Grievance Committee, you have those violations. My clients do not. Their violations lie in a failure to supervise. That lies in neglect. It does not lie in dishonesty, which is an intentional venal act. An intentional venal act, such as they were alleged to have committed, and there was some incorrect factual basis that the appellate division came to, requires intent and knowledge. Justice Castell said, based on this record, there is insufficient knowledge, and I cannot say that these lawyers acted dishonestly, okay, or intentionally, but I'm going to sanction the law firm. You then take that record, and you could take a look at the pages of the record in his proceedings. He lays out all of the different things that Mr. Smoliar misrepresented to the court repeatedly.
Ms.
And
Scalise,
somehow,
I just want to interrupt before you sit. I have a little bit of a concern with the conclusion that the only place these findings can come from is the Smoliar mitigation hearing, simply because just analyzing the text of the appellate division's findings, I noticed that it tracks almost word for word language that appears in the grievance committee's decision in order. So it makes me wonder whether, in fact, the appellate division is getting this from Smoliar, as you claim, or they're just parroting language from the grievance order.
so they specifically reference the language. If you would hold up Smoliar's decision and the language from the grievance committee in the Southern District on Smoliar, and you hold up the decisions from Mr. Hallock and Ms. Malerba, there's no mention of the charges of 8.4A, B, and C. There's no mirror image of that. The charges that were alleged and the censure that was found is based on 8.4H, as well as the failure to supervise rules.
But I think
Under a failure to supervise.
I think Judge Canataro is asking something a little bit different, or maybe not, but let me try and ask it this way. Can you point to any fact that is in the decision of the appellate division that is not in, that must have come from Smoliar? Any
Yes.
fact?
Yes. So with respect to Ms. Malerba, and give me just a moment to find my page. Okay. There's nothing in Judge Castell's order or in the Southern District order that implicates her involvement in the attorney's affidavit. Okay, so you have three different affidavits. You have the Lucier affidavit, you have the attorney's affidavit, and then you have a subsequent affidavit, which Mr. Smoliar retracts some of his first things, and then another affidavit where he retracts that. And the last two affidavits by Mr. Smoliar were with the benefit of counsel. So basically, Ms. Malerba was not asked by the court to address the attorney's affidavit because it was Mr. Hallock who prepared that, suggested to Mr. Smoliar, this is what you could possibly say, and then Mr. Smoliar signed it. He was the only one who knew the actual facts of what had happened in that affidavit. There is inconsistencies in the emails, and I think Judge Castell, drops a footnote. Mr. Halleck's emails are dated the 22nd, and Mr. Smoliar's are dated the 25th, so someone altered an email. So there is an inconsistency there, but more importantly, in the decision by the appellate division, they say that Ms. Malerba participated in the creation of that affidavit, and she did not.
But here's the thing, and I think Judge Wilson understands the nature of my question. If you go to the very first page of the grievance committee decision, it uses those exact same words. And I'm talking about the Malerba decision, not Smoliar. That Malerba assisted in the submission of a sham affidavit on behalf of her client, failed to supervise an attorney who drafted it, and then assisted in submitting to the courts a letter that contained false statements. Now, I realize that that is not a factual finding. I realize that that's a recitation of an order to show cause.
That's correct.
However, it just strikes me as interesting that the language tracks practically word for word from this language in the grievance committee's decision to the findings of the appellate division. And it makes me wonder whether it is indeed the case, as you say, the only place this could have come from, the appellate division, is the Smoliar hearing.
Yes. So what under Malerba's decision, if you take a look at the language at page 8 of the opinion, okay, it says, based on the foregoing, we find that imposition of reciprocal discipline is warranted. Not only did respondent assist in the submission of the Lucier affidavit, but she subsequently assisted in the submission of the second filing to cover up the fraudulent filing, although less culpable and so on. Here's the bottom line. She did not assist in that filing. That was Mr. Hallock suggesting to Mr. Smoliar, and Mr. Hallock filed that. Thereafter, she was asked by the court to explain the inconsistencies when Mr. Smoliar retracted things, and that's where she gets involved. So they make a mistake of fact, and she gets a 6-month suspension based on that. And by the way, if you read through Judge Castell's opinion, the Southern District Grievance Committee opinion, our clients consistently maintained that they knew nothing about Smoliar's initial Lucier affidavit. He then admitted on cross-examination by the Grievance Committee that no one told him to do it that way. He decided to do it that way. A unilateral decision. How can they be possibly sanctioned for doing something dishonest that they did not know about? He's the one who's called the liar. He's the lone wolf actor. He's repeatedly, if you look at Judge Castell's decision, it's replete with all the things he did wrong. He's got a 54H violation. He's got a Rule 11 violation.
Let me ask you this, because your time's almost up.
Yes.
If we did remit, it seems to me that the remedy you're asking for is not a remittal, but an actual change of the finding. Is that correct?
Yes, we would ask that you dismiss the dishonesty charges. And that under the case of Dondi, which is a 1984 case, which is the last time that this court had a due process violation, and it's analogous because of the number of years that this has gone on. We would also state that it would be equitable under the circumstances to dismiss the charge of dishonesty. Ms. Malerba is back to practice. That's not the issue. Mr. Hallock is still suspended. He's awaiting a hearing at the grievance committee for his reinstatement. He had a 1-year suspension, it is unopposed, and he still is not reinstated.
Can
So
I
we
just
think-
ask you, Ms. Scalise, how do
Yes.
you're asking us to find a due process violation.
Yes.
But how do we do that without explicit references to facts outside the record, explicitly?
Unfortunately, you can't answer something that you don't know about. So if you're not charged with something, and we have a whole section of our brief of all the things that would have been questioned, but you don't even have to go that far. You can go into Judge Castell's opinion. He's the original fact finder. He was there. He saw what happened. And he tells you all of the inconsistencies. And he tells the court, I'm not going to resolve some of these, and I can't because my record is insufficient. But it's there for the future grievance investigation. And Judge Castell, by the way, was a member of the disciplinary committee in the first department before he became a judge, and then he was the head of the grievance committee in the Southern District. So he's very familiar with how these things work. And I think that that footnote is very important for you to understand, because he's saying, there's so many inconsistencies that I can't resolve, and I am just going to sanction the law firm because I don't know that they have knowledge. It's insufficient. So he's saying, you need more to look at this. There's too many things that I can't figure out. And yet, the committee did not do that, and the court did not do that. The committee can regularly supplement charges. They don't have to just go on the reciprocal discipline. If you take a look at the record that is here, they said, based on what is before the grievance committee for the Southern District, they should be reciprocally disciplined. They did not add anything about dishonesty. They said, based on the underlying record from the Southern District, there is nothing that says, we think you were dishonest, and answer for it. It would be a simple thing to amend. And if the court felt that there was some inconsistency, instead of using the Smoliar decision, which is a separate disciplinary proceeding that is confidential, they could have sua sponte, held on to Smoliar because cases were pending at the same time, and decided who was telling the truth. Okay, they could have shot it back, and I've seen this happen in other cases, where they could say, we don't think so,
But I thought the
amend your
Smoliar,
pleadings.
I'm sorry, I thought the Smoliar Appellate Division decision came out, I think, before the orders to show
That's
cause in the
correct.
Southern District grievance. So don't you think the Appellate Division has an obligation to protect the consumer, the public in New York, that they're going to wait for the grievance committee in the Southern District to do that?
Well, that may be correct, but that's not what happened. They could have sua sponte opened a proceeding based on Smoliar. They waited for
Yeah,
the
but I
Southern...
thought you just said, like, they should have waited on Smoliar.
Well, once Smoliar's opinion is, there, okay? What they did when they created the Smoliar opinion were a lot of conclusions about what our clients did, and they weren't there to defend them or explain them, right? I don't know that there's any case law anywhere else where you can have a decision in one case where the people were not given notice or opportunity to be heard or to cross-examine or credibility examined, and make that like a collateral estoppel in the second case, and find that these people did more than that actually was found in 2 federal proceedings. And that's where the due process violation lies, because they never got to say, we don't agree. The Smoliar decision comes to conclusions about our clients that were not even in the record. They just assumed that Ms. Malerba participated in things, and because I think you said it best, Judge, you said, didn't they want to do this for sanction? But that's not enough. If you're going to sanction an attorney and you're going to take their license and their livelihood away, and by the way, an attorney's word is their bond. You say that an attorney is dishonest, it's out there in the public forever. This is something that is really important for you to understand. There's a scarlet letter on my clients branding them that they're dishonest, and they never got the time to dispute that. That is inherently unfair. That is a violation of due process, and we ask respectfully that you dismiss the dishonesty charge, that you remand it back to the appellate division, and that you allow Mr. Hallock to get reinstated immediately based on the Dondi case because of what happened being so inherently unfair and a due process issue. And you may be concerned, what about what happens after this? It is so rare to have a due process violation like this. The last time it happened was 1984. It's
Okay.
2021.
We have it. Thank you.
Thank you very much.
Thank you for your argument. Counsel, whenever you're ready.
Good afternoon. May it please the court. My name is Rona Kugler, and I represent the New York State Grievance Committee for the 10th Judicial District. The appellate division here properly imposed reciprocal discipline. There was no due process violation here, Your Honor, and there was no finding or charge of dishonesty.
But
with
there was a
relation to-
finding of dishonesty as to Malerba. I mean, it says it in the opinion. It says, we find the respondent's dishonest conduct merits suspension. Well, how is that not a finding of dishonesty?
Your Honor, I'm going to direct the court right now to Rule 5.1 D2 subsection 2.
Yeah, it's a vicarious liability, but this implies direct dishonesty. It doesn't seem to say you are third-party liability for the dishonesty of someone else. This says her dishonesty. I think you can argue that the Hallock one says that because they phrased it differently, dishonest conduct by an attorney. But when you read the two side by side, and you clearly see with Malerba, they're saying she engaged in dishonest conduct, and that was not as bad as what Hallock did. I think the inference is pretty strong that he found that he engaged in, the appellate division found he engaged in dishonest conduct also. So where is the finding of dishonest conduct by Malerba supported in the record?
Your Honor, I am going to direct you to, I know you're saying not to address the vicarious liability, but I say that that's
Do you
exactly
think
what we
when I
have
say
here.
somebody is dishonest, has engaged in dishonest conduct, that seems to me strongly, and this is attorney discipline. I mean, it is true. This is out there. This is the record of this attorney. This is their disciplinary record. When you say you've engaged in dishonest conduct, shouldn't you then really be careful to be saying you are responsible for the dishonest conduct of someone else because of the rule? I mean, that seems to me a very different conclusion.
Well, Your Honor, two things. First of all, Ms. Malerba did admit to violating the rules, all four of these charges, 5.1, B, and D, and 8.4. But, even beyond that, I know what you're saying, but the statute and the court precedent, for example, I'm going to direct the court to a matter of Schwartz. The court said that they are personally liable as though they had engaged in this conduct of the attorney that they were supervising.
Well, I thought the appellate division asserted that Malerba subsequently assisted in the submission of a second filing to cover up the fraudulent filing. All right, are you saying that that is factually correct?
What I'm saying, Your Honor, is,
Well,
As
I'd
far
like
as-
you to answer my question. Is that factually correct? Did she assist in the submission of a second filing to cover up a fraudulent filing?
I would say the record supports that, Your Honor. And I would say it because when we looked at the facts of what happened when the second filing was made to the court, at that point, Judge Castell told Mr. Hallock that he needed to submit an affidavit regarding what had happened, and that what happened is he said in his declarations to the court that he at that point reached out and consulted with Ms. Malerba as in relation to what had happened there.
All right, let me ask another question then. I understand your answer is yes, you're saying the record supports that.
Yes.
The second question is the Smolier attorney affidavit. Did Malerba have any involvement in the submission or the preparation of that affidavit?
As far as this record goes, there's no indication of what involvement she had. Obviously, she's very different than Mr. Halleck's involvement having drafted.
I just want you to answer my question. Did she have, do you think the record shows that? And where should I look to say that she had some involvement in the preparation or submission of Malerba's attorney affidavit?
Her involvement, Your Honor, was the fact that she knew at that time what was going on, that she had an obligation by these rules to try to mitigate any problems at that point. That would be involved in contacting Mr. Smolier and consulting with Mr. Hallock before an affidavit that was fraught with inaccuracies was submitted to the court.
Ms. Kluger, though, doesn't the district court, they find that there was no venal intent here? So how does the record then become so expansive to include that dishonest conduct, if not for the Smollier separate hearing? Like,
Well,
how does that expansion of the record happen?
Your Honor, I submit that the record was not expanded here at all. What happened is you have a situation where the rules that they admitted to and that they were found having violated show that you don't have to have knowledge, no actual knowledge needed, no intent, Your Honor. They have the same intent, the same responsibility as the attorney that they are supervising.
But counsel, that's the essence of vicarious liability, and I don't know, it gets us right back to where Judge Garcia was. You have to take this language out of the appellate division findings and imbue it with meaning far beyond everyday vocabulary and usage to see vicarious liability. I mean, the statement is, we find that respondent Malerba's dishonest conduct merits suspension. I mean, that doesn't sound like the language of vicarious responsibility for another person's actions, does it?
When you read what happened in connection with the rules, yes, it does, Your Honor.
So can I ask you a couple of procedural things? On a reciprocal discipline proceeding, can you expand the record without notice?
No, Your Honor. The record is what we had at the foreign jurisdiction
I'm not
before.
asking what you did. Can you do that? Or would you agree that if you were going to expand the record, you have to provide notice? Or at least start a whole new proceeding and not treat it as reciprocal discipline?
Yes, if you were going to expand the record, you would need to provide notice. That's correct, Your Honor.
Okay, and if you were going to sort of evaluate additional charges that the original jurisdiction hadn't considered, you would have to provide notice or start a different proceeding?
Yes, exactly. That is the essence of due process. They would need notice.
Okay, and what about if you were going to just enhance a penalty for something? Would you need notice there or no, in your view?
No, Your Honor, because what happens here is the appellate division has the the authority to exercise its discretion in determining what a proper sanction is.
And
Your
it's
Honor,
not bound by the federal court's determination of what, on the same record, I
no,
assume?
it is absolutely not. It is required or authorized to not only give a sanction that is consistent with its precedent, but I'm also going to say that the appellate court here, New York State, where the appellants live and practice law, have a greater interest in the sanctions than the foreign jurisdiction, because this is where they practice, this is where their lives are. And here, in the other jurisdiction, I want to point out, Your Honor, that the stakes were different, because Ms. Malerba was not admitted in the Southern District in the federal court, and Mr. Hallock, who was admitted, was permitted to voluntarily resign simultaneously with the imposition of censure there.
And was the
I'm
legal,
sorry.
was the legal standard for the sanctions imposed by the federal court under Rule 11 and the inherent power of the court and section, if I remember it right, 1837 maybe? It was, that is, they're operating under a different set of standards. Is that legal standards, is that fair?
Yes, Your Honor.
Counsel, what's our standard of review of the penalty?
Oh, well, Your Honor, this court should not be, precedent says, should not be substituting its judgment for the appellate division as long as the appellate division did not exercise proper discretion.
So it's an abuse of discretion standard.
Yes, Your Honor.
So what I was asking your opponents here, if there's some finding supporting the penalty, is that an abuse, that isn't supported by the record, is that an abuse of discretion? I'm just asking you as a general matter, not in this case, not the specific finding here. But if there is a finding used by the court to support a penalty, would that be an abuse, and it's not supported by the record, would that be an abuse of discretion?
If there's a finding that was not supported by the record, yes, Your Honor, because then the court would have gone beyond. Yes, Your
Okay.
Honor. Okay. But of course, Your Honor, that's not what
I know
happened
you
here.
dispute that.
Okay. All right. In addition,
No,
do you
you
have a
go
question,
ahead.
Your Honor?
No, I'm fine, you go ahead.
Okay. In addition, I just want to point out that the sanctions imposed here were consistent with New York State precedent. I'm sure you've seen in my cases, in my brief, there were a number of cases here where similar conduct garnered the same sanctions, 6-month and 1-year suspensions. for conduct where someone had forged documents, falsely swore or signatures as genuine and submitted them to the court. I have several cases such as matter of Glotzer.
But those cases are for knowing and intentional misconduct, correct?
Your Honor, if I recall correctly, I believe that at least one of them was the supervision of one of their attorneys. So it wasn't just their own conduct, it was the respondent in the matter. I'm not sure which case it is right now, but not all of them. Your
Somewhat
Honor.
related to that last question, it seems as if in general, and maybe you can educate me about the exceptions, that the suspension remedy seems to apply when there are multiple instances of this kind of misbehavior, whereas censure seems to be the more normal penalty for one-off conduct. And this is, as far as we know, a situation involving one-off conduct. So does that, does that seem, would that rise to the level of abuse of discretion?
Well, Your Honor, this may have been one case, but there were two situations here of what had happened. There was the initial false filing of the affidavit of the client, and then there was a subsequent cover-up. So I want to say that was actually two situations where false information was submitted to the court. In addition, it would not be abuse of discretion because it is in the general range. Each of these cases are very fact-specific when we look at the decisions of the other matters. And the facts here would support that. It would not be an abuse of discretion. It's in the reasonable names set of range of sanctions that the court has given. We're
Okay.
not talking about like a 7-year suspension or a disbarment. They're very close, and it's very consistent.
Thank you, Counselor.
Oh, thank you, Your Honor.
All right, got 3 minutes, ma'am.
Thank you, Your Honor. There was a question posed, and I apologize because of the mask, I don't know who posed it.
It's okay.
But one of the issue was, based on these facts, can you reach this? Based on these facts, you cannot reach this because there was not a dishonesty finding by Judge Castell or by the Southern District. The only way you can reach this is if you rely on what Mr. Smoliar did, and Judge Castell's record is replete with all of the inconsistencies and what he says, and most of his record is dedicated to all the things that Smoliar did wrong. The only way that our appellate division could have gotten to the conclusions about our clients was to do what they did, was relying on the facts of the Smoliar case.
You're lumping that a lot together because the Southern District, Judge Castell went beyond the lone wolf. In fact, he says you're not being sanctioned as a law firm, which is what he could do, because you have a lone wolf. It's because you've done these other things. Now, I take your point that doesn't rise to dishonesty, but it wasn't that you had a lone wolf employee. I mean, some of the things he found were you could have discovered this conduct, again, all part of the charges that were levied, but that you admitted to. But, look, you found one, and that was just because of this. You didn't check with the client once you knew there was a problem. All of those things Judge Castell lays out. So I think it's somewhat inaccurate to say, at least to Hallock, that it was because they had a lone wolf employee. It went beyond that, and I think
And I agree
that
with
underlies the charges here, which are very serious.
And I agree with that, except that that lone wolf was the person who provided information again and again to the court, which it then came out to be untrue, which he then retracted again. Our clients were the ones who figured out that he had done this before and tell the court about this. He then gets credited by the appellate division, and the appellate division in Smoliar's decision takes for granted everything that he says and says things about our clients. There are two separate proceedings. If the appellate division could have done this without Smoliar's findings, and by the way, it was the same panel a year later, they would have done so. The record, what you're talking about, the things that happened, they lie in negligence or neglect. There was no intent to mislead because the reliance was on Smoliar. So when Mr. Hallock spoke to Mr. Smoliar in order to draft an affidavit for him, it was based on information that Mr. Smoliar gave, okay? The information that he, imparts in the record and that the court relies on is inaccurate, and our clients never got a chance to dispute that. The
No, I
committee...
take your argument. My
Yes.
only point was, I think there is a difference in the district court opinion between you're liable because you had a lone wolf and what Judge Castell actually
And
based
I
his sanction of the firm on, which was conduct beyond that, which I think went to D Romanet 2, which was, you should have known, you had an opportunity to do something at the time, and it was very easy for you to find the other example later, but you should have really done more originally.
But
That's how I take Judge Castell's finding.
And-
And again, I take your point that that is not dishonesty, but I think it goes well beyond, I just had a rogue employee who I failed to supervise.
But what the court says at page 68 of Ms. Malerba is this: while the record before the court is not sufficient to support a finding of actual knowledge on the part of Mr. Hallock of the falsity of the attorney's affidavit, and by the way, that's affidavit number 2, the record also does not support a finding there are exceptional circumstances that warrant accepting the law firm for joint responsibility. But joint responsibility for what happened does not mean that they had knowledge that it was false, okay? You are taking a quantum leap. They're relying on an employee who gives them information that is incorrect, okay? That does not mean that Mr. Hallock intentionally tried to mislead the court. Unfortunately, if you take a look at the timeline, things happened in a very short time period, and as they, unfolded, what you hear is, first, the false affidavit, the client testifies, I didn't sign this. Mr. Hallock did speak to the client and said, you had your affidavit, and she said yes. He puts this in the record. He puts it in the record with Judge Castelli, puts it in the record in the Southern District. So, consistently, he's explaining
I'm sorry,
why he did
just, can we
or
go
did
back
not
to
do
that?
what he...
I'm sorry, that point where he shows it to the client, I
Yes.
thought the point there was she didn't say anything. Not
That's
that
not
she said
correct.
I signed it.
So there were two different things, okay? He was prepping the client for trial, and it's in the record, and he showed it to her, and she didn't deny that it was hers.
She didn't say anything.
Well, she said, okay, and then when she was asked at trial, she's referring to the affidavit that you give for HIPAA forms, and that's what Ms. Malerba explained later, the affidavit they had. And by the way, Judge Castell does not credit Mr. Smoliar's thing that Ms. Malerba told him that there was these affidavits and she had authorization to to sign and notarize things on her behalf. He does not credit that, okay? So what happens is he does this unilaterally, and he admits in his grievance committee cross-examination that no one told him to do it, he just did it, okay? So on cross-examination in his hearing, he admits that. How does that then come to the point where he was told to do that? That's inaccurate. He unilaterally decided to put that in. When you're then Mr. Hallock, and you put yourself in his shoes, at the hearing or the trial, she thinks it's one thing, and then it turns out to be another thing. In order for Mr. Hallock to prepare suggested language for Smoliar, he had to talk to Smoliar to figure out what happened. And that's when he learned what had happened. And he consistently explains that, it was a misapprehension on her part because she was thinking about the one affidavit and, for permission for the HIPAAs, and Ms. Malerba explained that as well. And Judge Castell says, Smoliar is experienced. He knew the difference. He didn't have to sign that affidavit. He knew what was wrong. And that's
Okay.
the point.
Your light's on now, so why don't you wrap it up?
Thank you very much.
Take your second and wrap it up.
Okay. So to conclude this, and if you give me just a moment.
Sure.
This matter was unprecedented. The practice of the appellate division should not be condoned or countenanced. Our clients were suspended and served their time and then some. Mr. Hallock is still suspended. The public interest has been served in this case. What is the public interest? They're to know that there was misconduct. What was the misconduct? The failure to supervise someone who did something wrong. And to discover, you're right, Judge Garcia, that he had done it wrong. But that's a should have known, not what they knew. And dishonesty lies in intentional acts, okay? So the remedy is to vacate the determination of dishonesty to dismiss any further proceedings against Mr. Hallock, and there's no reason to admit, only to the effect that doing so would unnecessarily continue to punish my client for something that he never had the ability to defend, and she never had the ability to defend, based on the record of the fact finder. Even Judge Castell did not find they had knowledge of what happened. Insufficient knowledge. His statement is that he was going to sanction the law firm because the law firm should have known. But these two individual lawyers, there's a quantum leap that they're dishonest based on what Smoliar said and did. That is unacceptable because they had no ability to be in his proceeding. And they had no ability to challenge what happened in his proceeding. Now, that may have resulted, if they had had a dishonesty charge, in inconsistent findings. But what the appellate division could have done then, if they found and they gave our clients a hearing, they could have brought subsequent charges against Mr. Smoliar if they thought that he was dishonest instead of my clients, and because you can't lie in a disciplinary committee proceeding, and there's no statute of limitations or latches. But here, they made a determination. They wanted to just stick with the facts that they found in Smoliar. They then used them against our client in a separate proceeding, which was inherently unfair and violated their due process because they had no notice that they did anything dishonest. They had initially allegations of that, but what Judge Castell found and what the Southern District found does not lie in dishonesty. Someone said vicarious liability. There's vicarious liability, but that doesn't mean you knew about it. You might be liable because you were supposed to supervise. It does not mean that there was knowledge, and that's what's really important to understand here. So to not give them their due process and to later wake up one day and there's a decision by the appellate division labeling you as dishonest, giving you your scarlet letter, ruining your reputation is inherently unfair, and therefore we seek the dismissal of the dishonesty charge and the recommendation based on Dondi that Mr. Hallock be reinstated immediately, and I thank you very much for your time and consideration of this case.
Thank you, ma'am.